Can I get more than 50% of the assets in divorce? Hi, I'm Bill Farias, founder and CEO of Farias Family Law. We're a Massachusetts divorce and custody firm. And this is a really common question. People moving toward divorce, and you want to figure out, what am I going to get out of this? And many people feel like they should have more than 50% of the assets, either because they've contributed more or the other side has been wasteful. And so what I want to do is give you the main factors that are considered by the court in determining whether there should be a disproportionate division of the assets. So first of all, Massachusetts is an equitable distribution state. And that doesn't really give us a lot of information other than the court is trying to distribute assets in a way that is fair. What is fair really depends on the circumstances. One of the key factors in determining whether there should be anything other than a 50-50 split of marital assets is the length of the marriage. And the reason this is so important is because the longer the marriage, the more likely it is that courts are going to weigh more heavily factors that are relevant to whether the financially weaker party is going to be okay financially after divorce. And this makes sense because the longer the marriage, the more dependent the financially weaker spouse has become, and the less likely it is that the financially weaker spouse is going to be able to earn more and acquire more assets. So the longer the marriage, the less these other factors I am going to tell you about weigh heavily. So in shorter marriages, these factors weigh more heavily. In longer marriages, they don't carry as much weight. And there is not exactly a presumption of 50-50, but it is more likely to be closer to 50-50 if it is a longer marriage. So what are those other factors? Contributions to the marriage, certainly important. It is important to know that the court considers both economic and non-economic contributions. So you could have one spouse going out and earning the money and paying the bills, and the other spouse taking care of the children, taking care of the home. So non-economic contributions are important. The time when those assets were acquired is also important. So if, for example, a couple is on the outs, divorce is filed, and then an asset is acquired, that may play a role in how the assets are ultimately distributed. For example, if someone gets an inheritance like late in the marriage after the divorce is filed, or if someone received property or already had property before the parties got married, that also might factor into how the assets are divided. Whether the assets, another factor, whether the assets have been commingled during the marriage. And commingled just means mixed. So think of it as, if there are assets that are only in one party's name, have those assets been mixed with marital assets? So perfect example is, someone had a home before the marriage, they sold that home, they took the money in that home and they pumped it into another home for the family, for the married couple. Those assets are commingled. Or someone gets an inheritance and they take that money and they invest it in the family, or they put it in a joint brokerage account. That money is commingled. This is different than someone having an asset only in his or her name and keeping it separate during the marriage and not mixing it with marital property. That is another factor that's considered. And finally, waste. So there are a lot of different activities that fall into this category. It's referred to as dissipation of marital assets, but you have to think about someone doing with money during the marriage what they shouldn't be doing. One example we had a case that involved somebody gambling away $250,000. If there is an affair and someone is spending on that affair, that's money that would be considered a dissipation of marital assets. So If the money is used in a way that it shouldn't be used, then that's something that the court can consider. Heavy drug and alcohol abuse. That's another example. So if it's used in a way that doesn't really contribute to the marriage, then the other party, the party who wasn't using the money that way, can ask for a credit. So the main ones here are contributions to the marriage, economic and non-economic. When those assets were acquired, especially if they are assets that are held individually in one party's name, when did the individual receive those assets? If it was before the marriage or at the tail end of the marriage after the divorce was filed, that's something the court can consider. The commingling of assets, the mixing of assets held in one person's name with marital assets is a consideration. If it's mixed, it's more likely to be marital property. And waste. So spending money on basically things you shouldn't be spending on. And again, the length of the marriage is the key factor, because the longer the marriage, the less weight the judge is going to give to these other factors, because there are factors relevant to the financially weaker party's long-term financial stability that come into play. So the longer the marriage, the more likely it is to be 50-50, but it doesn't mean that it will be 50-50. All of these factors are important. If you have any questions, call us 508-675-0464. You can email us at info@fariasfamilylaw.com. If you found this video helpful, you can like, subscribe, share, and you can find us on social at Farias Family Law. Thank you. Have a good day.